All right, so before we get going with our panelists, I just want to zoom out briefly to frame the panel and talk about what are we meaning? What are we saying when we talk about a second look law? These are laws that allow a person to ask for their sentence to be re-examined by a judge after a certain period of time. And what we will be talking about today is, what would an ideal second look law look like? What are some of the laws that are out there, and how do they handle the variety of requirements that people are putting into these laws? So some of the things and the requirements for these laws are how long a person has been in prison. So they wouldn't be eligible to get a second look until they've served some portion of their sentence. Other considerations are the person's age at the time that they're asking for the second look, or their age at the time of the offense. And then, of course, there's the type of offense. So there's people talking about, should certain types of violent crimes be excluded? How should we formulate laws so that the broadest number of people can move to have their sentences re-examined? We'll talk about how there is a lot of momentum right now for second look laws around the country. These laws are, I think, really vital to beginning to unwind mass incarceration, advancing racial justice, promoting public safety, and repairing the incredibly damaging harms of our system to families, to communities, and to people. What we know is that people grow and change. And right now, our laws do a really terrible job of reflecting that. So with that, I want to welcome our panelists today. We first have Mary Price, who is the General Counsel at FAMM, previously Families Against Mandatory Minimums. FAMM fights for more justice in the criminal legal system than almost any other organization, and has a really robust second chances agenda. I think it's fair to say that the work that so many of us are doing around second chances, second looks, clemency, and compassionate release stands on the shoulders of true giants like Mary. She has been with FAMM for over 20 years, and she is an expert on clemency, compassionate release, mandatory minimums, and much more. And she's also just an incredibly kind and generous mentor to so many of us who are doing this work. Next, we have Santia Nance, who is one of the 3 co-founders of the Sistas in Prison Reform, along with Pauletra James and Juanita Belton. And Santia, Pauletra, and Juanita are fighting for a second look law in Virginia. And their fight is happening right now this week. And Santia will tell you about some of the developments later in the session. I am incredibly inspired by what they're doing. I think it shows the power of community and grassroots advocacy, and really advocacy that is just grounded in love for human beings. Next, we have Arienne Jones, who is a senior policy advisor in the Cook County State's Attorney's Office. She is spearheading the implementation of Illinois' new prosecutor-initiated second look law, which allows prosecutors to request a sentencing reduction in certain categories of cases. Prosecutor-initiated second look laws are also gaining some momentum around the country, and Arienne will share with us the promise they hold for second chances and how we can most effectively use them to complement other second looks. Finally, we have James Zeigler, who is the founder and executive director of the Second Look Project, which is an incredible organization that is working to provide more second chances for DC residents. The Second Look Project engages in litigation support for attorneys who are litigating compassionate release and second look cases under DC's laws. They are pursuing advocacy, and they are also providing direct representation to people who are seeking a second look. So all of our panelists are going to be doing a brief introduction of the work and where they see things with second look laws right now. They're also going to share what a second chance means to them in the course of that introduction, and then we will open it up to questions. I want to share just briefly what a second chance means to me. I always come back to Brian Stevenson and his quote that all of us are more than the worst thing that we've ever done. And that's something that I think of for everyone in my life, myself included, and particularly our clients. So with that, Mary, I will turn it over to you first.
Thanks a lot. Thanks for that lovely introduction, and congratulations on 10 years. You asked about what second chances means to us. I kind of got into thinking about second look sort of through a back door in some sense a back door, via my work on compassionate release, which has been a focus of mine for many years. Compassionate release has generally meant early release opportunities for people who are aging and debilitated or terminally ill, and we talked about that a lot in our last session. In the federal system, compassionate release is one of the very few exceptions to an overriding rule of finality in convictions, right? So we don't have second look in federal law. In the mid-1980s, Congress passed the Sentencing Reform Act, and despite its rather promising sounding name, which had the word reform in it, it eliminated parole. It slashed the amount of good time that an individual could earn against their sentence, and it ushered in an era of determinate sentencing. So that addiction to finality is enshrined in one of our sentencing laws at 18 U.S.C. section 3582, and it begins by saying the court may not modify a term of imprisonment once it's been imposed. Now, happily, that same law carves out a few narrow exceptions to the rule, and one of those is for compassionate release. And compassionate release is provided for when an individual develops what our law calls extraordinary and compelling reasons warranting release. And so when I think about the justifications for compassionate release, and for that matter, for any second look tool, I think about the purposes of sentencing. What is it we're trying to accomplish when we lock somebody up? And I think it's pretty useful to think about second look through the lens of the purposes of punishment. I mean, given the extraordinary deprivation that life in a cage imposes, we should be sure we're not only doing it for the right reasons, but we're also checking in from time to time, or when things change, to be sure that those reasons still support imprisonment, right? So our system incarcerates people hoping to do a few things. One, to deter crimes, to punish people who commit them, to protect the public, and to rehabilitate people who are going to return home someday. People should have a meaningful opportunity, though, to leave prison when their continued incarceration no longer advances those ends, right? At a minimum, we should consider people who are dying and aged, and people who are too debilitated to offend, or too compromised to benefit from rehabilitation, or too impaired to be even aware that they're being punished. And you'd think that those would be the easy cases, but if you were at the last panel, you know they're not. Compassionate release is rarely used. But the principle that a sentence has outlived its purpose shouldn't just apply when a person's medically vulnerable, in our view. We should provide the chance for anybody to make the case that a sentence that might have been considered just and proportionate at the time it was imposed can become disproportionate and unduly severe in light of changed circumstances or changed views. So second look means we should provide an opportunity to revisit a sentence when circumstances or the passage of time or rehabilitation compel a change, or when we abandon a scheme as unjust and unfair and disproportionate, or one that results in unjustifiable disparity. So, for example, when a person has served some period of time and demonstrated growth and maturity and rehabilitation, to the extent that keeping them locked up doesn't keep us safer and isn't necessary for deterrence, won't do anything more to foster rehabilitation, then continuing to do that is excessive. But it isn't just individual growth and the passage of time that should trigger second look, right? Consider also the situation where our criminal legal system's view on what's an appropriate sentence changes. Our views evolve. They evolve when we no longer sentence children to adult-sized terms of imprisonment because we understand more about those children's capacity to understand and guard their actions. We evolve as a system when our criminal legal system comes to terms with the fact that the sentence required by law is too long and reduces that sentence. And when we make those kind of changes, we have to be sure we don't leave anybody behind. We shouldn't leave anybody behind serving the sentences that we have turned our backs on. And to kind of think about that as our system undergoing its own rehabilitation. So I think essential guideposts to understanding what is excessive are those traditional purposes of punishment. I mean, mercy and compassion are a big part of that as well. But I think we always have to, second look has to be a course correction to ensure that we routinely assess a term against the reasons for imposing it. And I'm sorry, I talked a long time. Maybe I can talk about the federal system later, but thanks.
I'm Santia Nance. I'm a co-founder of Sistas in Prison Reform out of Virginia, which I know you mentioned, Erica, but I always got to shout out my other two sisters, Juanita Belton and Pauletta James, who I know are watching. At a high level, the Sistas in Prison Reform, we're a grassroots group fighting to end mass incarceration through advocacy work here in Virginia. I think it's important, again, to point out that we are not lawyers. We are not policy specialists. We are just passionate individuals who have full-time jobs outside of this industry, but just a great passion for fixing the system in our nation, and especially in Virginia, because there's just a lot of issues in Virginia. And that is where our loved ones have spent their time incarcerated. A little bit about our work. Our focus lies in solutions for people who have been behind bars way too long. We saw a hole in the Virginia system where there's just a lot of people who are forgotten about and are just warehousing human bodies in Virginia. But this includes a few different things that we're doing. So one, we're advocating for and sometimes creating or co-authoring legislation that affords opportunity to people behind the walls who have been sentenced excessively. And to us, that means 10, 15, 20 years for serious offenses due to the tough on crime era in the 90s. So if you guys don't know, Virginia abolished parole in 1995. So we definitely know that there's a lot of things that need to be undone about that era. But this includes, but isn't limited to, second look, of course, anything parole related, resentencing, earned sentence and good time credits, ending mandatory minimums, and any positive policy and Virginia code updates regarding post-conviction. That's oversight of the DOC and any other legislation that just allows for a more fair system. The other big pillar we look at is humanizing our loved ones and hoping to inspire other people to humanize their loved ones by erasing the stigma caused by fear-mongering and dehumanization terms and behavior. So you will never hear us use the word inmate, and you will always hear us say our loved ones' names. Sometimes I'm like, man, I talk about them too much. But the reality is there just needs to be awareness behind the names and the faces behind bars to bring that sense of humanity to legislators and the public. Right now, our big hot topic, as we've already talked about, is second look. It's very hot and heavy with us. We started working on it back in May of 2021. We've done a lot of research, worked with a lot of different advocates in the space, worked with lawyers and lawmakers and just so many different people for the past X amount of months. But right now, the bill in itself, SB 378, I'm like, there's a lot of numbers. It actually passed the full Senate of Virginia, which is super awesome. And we're super excited about it. And it's on to the House of Delegates, which is going to be tough, but not impossible if time can prove that we, have been able to do this work. So we're super excited about continuing that fight and pushing it through the House of Delegates. The last thing I'll quickly mention, I know we talked about what does second chances mean to me. So second chances have been something I really didn't have to think about for much of my life until I reconnected with my loved one, my fiance, Quadair Patterson. I'm going to say his name because, again, that's so important to people in this space. But then my heart and my mind have opened up so much. And I feel like I see second chances in everything and everyone these days, just because, again, like he's kind of proven to me and shown me that is possible, even in the darkest places. And I truly believe that we're all capable of redemption, regardless of what we've been through, because I know every single one of us here in the audience or on the panel can name something that we've been through where you felt like you couldn't come back from it. And we know that that's what a lot of people in prison feel. And we want to make sure that they understand that they're all capable of redemption and that we're all capable of being compassionate to one another as humans.
So I'll just start with what second chances mean to me. And for me, they mean recognizing, like you said, Erica, Bryan Stevenson's call that people are more than the worst moment of their lives. And for me, second chances mean recognizing that reality by giving people grace and the opportunity to live robust and whole lives outside the confines of the criminal justice system. And that is ultimately what Senate Bill 2129, which is Illinois' prosecutor-initiated resentencing law, is meant to encompass. So in our conversations in the office, in the Cook County State's Attorney's Office, we recognize that if we want to truly reform and reimagine the criminal legal system and what justice is and should be, that prosecutors needed and need to play a role in fixing some of the harms that were caused by these offices and these roles, even if those harms were unintentional and based on what was thought to be best practice at the time they were imposed. So I'm gonna play the let me try to share my screen game. In the Cook County State's Attorney's Office, when we thought of SB 2129, we wanted it to be as broad as possible. So it is fully discretionary. No prosecutor has to use it. It's modeled after California's prosecutor-initiated resentencing law. They were the first in the nation to have it. And we like the fact that, again, it's discretionary on each county prosecutor. So the now law, which became effective on January 1st of this year, allows prosecutors at their discretion to ask a sentencing judge or whoever took over the sentencing judge's docket to resentence incarcerated people when prosecutors believe that those sentences no longer serve the interests of justice. And the interest of justice portion is a very broad statement, which again is really meant to be interpreted by each prosecutor in each county in Illinois, because we recognize that in the 100, I believe, 2 counties across Illinois, different prosecutors in different communities have different needs and beliefs, and we did not want to impose any particular edicts on anyone simply based on what our beliefs and experiences are here in Cook County. So, because I don't want to take up too much time, we're going to include, the law includes various factors that the court may consider, including records of rehabilitation and disciplinary records. And those are simply meant to guide the court and to give the court an idea of ways in which to really holistically look at a person so that it's not just who they were on the day they committed the crime, and so that they are not simply constantly looked at through the lens of their crime. And victims of crimes will be afforded every right they're currently afforded under Illinois law, which is the same amount of rights they are given throughout trial and sentencing. So the big two are notice and an opportunity to be heard. So in Cook County, we're notifying victims once we begin filing our motions and giving them the opportunity to weigh in or simply choose not to weigh in regarding someone's potential resentencing. So we're partnering with a variety of organizations, both formally and informally, in Cook County to make this as smooth of a process as possible. We've not yet resentenced our first candidates, but we are in the process of doing so. We've been working with For the People, a California-based organization that works with prosecutors' offices across the country to help them with their prosecutor-initiated resentencing or just conviction review work. Indeed, the executive director and founder of FTP is the author of California's Second Look legislation. We're also working with Precious Blood Ministry of Reconciliation, which is a wonderful Chicago-based organization that is helping each of the candidates we first identified with their reentry plans and with social biographies that we hope to show to the court to give the court a really full sense and idea of who each individual is. And each individual candidate for this first round is being represented pro bono by Winston and Strawn. So at the current time, we are not accepting applications for release for resentencing because we just need to really get our feet under us and develop our processes and perfect them as much as possible. But eventually, hopefully within the next few months, we will open that up to a request process and then evaluate requests as they come in. But right now, we're essentially focusing on 4 categories: folks who served 10 or more years for a drug-related offense or a theft, burglary, robbery-related offense, including armed robberies and aggravated robberies; those who are 65 or older and have served 20 or more years for a non-sex, non-homicide offense, and those who served 15 or more years for a non-sex, non-homicide offense that they committed when they were under 21. So some of the limits that we've recognized are that we can't make motions for anyone who has not served the minimum sentence. And we also cannot make motions for folks who are serving mandatory sentences like mandatory life, which is where the importance of things like clemency and the governor and the Joe Coleman Medical Release Act come in. The governor of Illinois has vast, vast, vast clemency powers, and only he can grant release to someone who is serving a mandatory life sentence or who's not served the minimum. Under the Joe Coleman Medical Release Act, which recently became law, those who are suffering from serious medical conditions may have accelerated consideration for release by the Prisoner Review Board, which is also going to be a quicker process than what we could do through the courts. And so prosecutor-initiated resentencing for us is not meant to take away from the governor's powers or from the PRB's powers, but simply to complement them and to give prosecutors the opportunity to remedy some of the harms of mass incarceration. So thank you.
I'll start with kind of what a second chance means to me, or kind of what it means to us. I'm in the unfortunate position of having to go after everybody else who I think really did such a good job of capturing kind of what second chances mean, especially in the context of the work that we all do. But in our work, I think one thing that really stands out to me is, second chances meaning and being an opportunity and a right to be considered and looked at and judged for the person you are now, and not the person you were 20 or 30 or even 10 or 5 years ago, and not judged for the things you did 10 or 20 or 30 years ago. And recognizing just how complex people are and the capacity for change people have, and all the things that go into a person's story that make it so that the person who stands in front of you on a given day may have so much that's led them to where they are. And I think what our work calls judges to do in DC and elsewhere, we're calling other decision makers to do, is really, let's look at all these people we have incarcerated. Let's look at them for who they are now and decide who needs to be incarcerated, and making that about who they are now and not about about who they were in the past or what they did in the past. And those things can matter and they shape who people are. But it's, I look back on myself and I made a lot of mistakes that luckily, didn't take me down the same path as many of our clients. But had I, been born in different circumstances and had less privilege than I did, they could have. But I look back at who I was when I was 20 years old, and I'm not the same person anymore. And so if I had made the kind of mistakes that my clients made when they were 20 years old, and you had locked me up, for 30 or 40 or 50 years, the person you locked up and threw away would not be the same person that I am now. And so it's like, who are we punishing? And I think, you're getting kind of, a little too abstract here, but, this kind of recognizing how the concept of like a person as this kind of fixed entity who can be kind of like judged at one point, that judgment should just carry in perpetuity into the future, and how much sense that really doesn't make when we kind of talk about who people are and how we change. Having the opportunity for a recognition of that, and for people to kind of get freedom as a result. And so, I'm here and I'm in these spaces largely because of the work that we're doing in DC that, really I kind of just hopped on for once it was well underway. But DC, I think, arguably has what is kind of the present gold standard or most robust second look resentencing law in the country. And I'll tell everyone a little bit about how our kind of law presently functions, and then kind of the history of how it has changed and got to where we are today. But our law allows anyone who is serving a sentence for an offense committed before they turn 25, after they have served at least 15 years, to petition the sentencing court for a sentence reduction and release. And it lists the number of factors that that the judges consider in making that decision, which really kind of take into account a petitioner's entire life story. And so we as advocates are kind of in the position of telling people stories and kind of figuring out how to do that in a way that convinces a judge that this is someone who doesn't need to be locked up anymore. And before a judge can make that decision, they have to make two threshold findings. The first being that a person is not a danger to the community, and the second, that the interests of justice warrant a sentence reduction. And so under that, our law, which is still presently limited based on age at the time of the offense, although that's the only constraint. There are no exclusions or constraints based on the type of offense committed, which I think is really important when we talk about these laws, not just because of the harm that exclusion would do to those categories of people who are excluded, but to the extent that cutting certain people out undermines the entire conceit of the law itself and really what we're talking about here, which is that capacity for change. And so that's where our law is now. It started in 2016 as a provision within a broader package of juvenile justice reforms. And what the law originally did was said that anyone who had served at least 20 years for an offense committed before they turned 18 could petition the trial court for resentencing and release, provided that they were not already eligible for parole. And so there were a couple little changes there. And importantly, our law was not originally drafted to be retroactive. So it would apply to people who got these sentences for offenses committed when they were kids going forward. But the 100+ people serving DC code sentences, the DC code being our local criminal law, who fell into that boat would not have had an opportunity for relief because they came after the fact. And when we talk about kind of advocacy efforts, the one thing that DC has showed us is just how much and how important family members and incarcerated people themselves are in this process, because it was the family members and the actual guys serving these sentences who heard about this law and heard that it wasn't retroactive. And they started writing letters and calling local legislators, and they're the ones who kind of applied the pressure to have it made retroactive, without which it wouldn't be nearly as impactful as it is. And so it was eventually passed. It went into effect in 2017. It was later amended to do three big things. The first was that it changed the amount of time served that's required for resentencing from 20 years to 15 years. It removed the requirement that someone not yet be eligible for parole, because what we came to find out, and this is true in a lot of jurisdictions, it's especially the case in DC, where our parole eligible incarcerated people go up in front of the U.S. Parole Commission, not a local administrative body. And the USPC is a body that has historically really not given DC guys and women, but our population is overwhelmingly men, but has not given those people a fair shake. And so realizing that there are a lot of people who really did need to come home, but who had been denied parole, they decided to remove the parole issue altogether. So even someone who's been denied parole can now seek resentencing under the IRAA, which we just kind of call IRA now. And the third thing that Second Amendment did was remove some language in the law that directed courts to consider the nature of the original offense. And that was done in response to the kind of the positions consistently being taken by the U.S. Attorney's Office, which is on the other side of these cases for us and have almost universally opposed resentencing in these cases. Because when the law was first passed, they would pretty consistently argue that, well, the original offense was so bad that this person is not worthy of resentencing, which is, for a law that required at the time people to have served 20 years for an offense committed when they were a kid, necessarily contemplates that this is going to be the most serious offenses. But they made that argument anyway. But the counsel kind of recognizing that this argument was being made and that it was not consistent with what their intent was, eliminated that nature of the offense language. And so that was the kind of first round of changes to the bill. And then in last year, a bill called the Second Look Amendment Act was passed, which amended IRA in a really significant way. And what it did was it expanded eligibility from people who were under 18 at the time of the offense to people who were under 25 at the time of the offense. And the reason for that was that the bill was really originally modeled around the Miller population and kind of the juvenile lifer concept. But, I think people realized how arbitrary and low that cutoff was at 18, especially knowing that the science is pretty clear that people don't really reach developmental maturity until their mid-20s. And so that change was made and went into effect last year, and it made probably between 500 and 600 people newly eligible. So it was a big leap forward in terms of the substance of our law, and it was really significant in terms of the number of people that it afforded this opportunity to. And now there's a push to just eliminate the age at the time of the offense criteria entirely, which I think we're optimistic about. And so I don't want to eat up too much of my time. I promised myself I'd watch the clock and figure out how much time I was taking, but I didn't. But things have gone very well. There have probably been about 80 to 85 people resentenced at this point, and about 15 motions for resentencing denied, which is a really great success rate. The challenge we face now after so radically expanding our eligible client population, is now getting lawyers to all those people and getting those cases litigated. And that would have been a huge undertaking under good circumstances. With COVID, with the courts kind of being where they are, and I think it was Allison on the last panel who talked about compassion fatigue, like judicial compassion fatigue. We're just seeing it so much, and everything is just kind of tooth and nail to get things done. It feels like these days, and so we are facing challenges with implementation and kind of getting everybody, not just representation, but the level of representation that these cases call for. But we're plugging away, and so we're optimistic about kind of where things are headed.
Thank you, James. And that's an amazing record of success in DC. Miri, I want to go back to you, because one of the things that James mentioned, I think, has been on my mind a lot as we're thinking about, getting these laws passed is, there's a huge number of people that may be eligible. And I know what Arienne said is that a private law firm is going to assume the representation of all the people that are eligible in Illinois. But how can we make sure there's a robust, access to counsel at this, back end stage, so that people get the representation that they deserve and they don't have to go into these hearings pro se?
That's an excellent question, and one that we struggled with, certainly in the compassionate release space, and that James just talked about in terms of getting lawyers to cover these cases in DC. So before COVID, actually, after passage of the First Step Act, there was a law passed in the federal system called the First Step Act, which one of the things it did was to expand the ability of judges to consider motions, not just from the Bureau of Prisons, but from individuals who are incarcerated, right, for compassionate release. And we realized that, for the many years before that, only the Bureau of Prisons could bring motions. They never did. And so judges didn't know, they didn't know about these, right? And we realized that we were going to have to educate the judiciary, and we really didn't want people going up by themselves pro se in these situations. And so we got together with some other organizations, the National Association of Criminal Defense Lawyers and the Washington Lawyers Committee, and we collaborated with the federal public defenders to build a compassionate release clearinghouse that would both identify individuals who were in need of compassionate release or eligible potentially, and then recruit and train and support the lawyers, pro bono lawyers, or identified federal public defenders who could take those cases. And for the most part, defenders took them. They took about 2/3 of them in that first year. But that whole project then just exploded during COVID. And at the beginning of COVID, when everybody's home and they don't know what they're doing and they're at wit's ends and they want to be helpful, we got a lot of lawyers signed up. I mean, I think we had 600 lawyers in the project, and we had screened like 5,000 cases, and I think we placed something like, I don't know, I can't remember how many, 2,000. But that began to fall off, right? I mean, you know, we had a number of cases, as I said, about 2/3 of them went to the defenders, and of course they took those and did amazing work. But it became harder and harder as COVID grew on, as people went back to work. We've drawn on as many resources as we can, and we certainly reach out to those of you in the clinical community because there's so much excellent and creative work going on there. We continue to try and find, but we didn't find lawyers for everybody. It wasn't possible. That said, I mean, building partnerships with some firms with good pro bono shops who were like, got it and did it was like an amazing thing. So I don't want to minimize at all the work that, you know, that those firms did, those individual lawyers did, clinical lawyers did, was amazing. But we came up short, I have to say, and I don't have the answer to, you know, how we cover everybody who's needed. Now, you know, the cases have fallen off a little bit now because COVID is theoretically gone, although, you know, certainly not entirely, as Allison talked about. But, you know, we're beginning to go back and look again at sort of more traditional cases, and also these excessive sentence cases that we're going to be talking about more as grounds for using compassionate release as a second look in the federal system.
Right. So it seems like as people are envisioning what they want a second look law to encompass, that access or right to counsel might be something to consider, at least, you know, as we're, you know, moving forward.
Yeah, I definitely putting in a provision that counsel can be appointed or should be appointed is a good one, but I'd want to defer to my friends who are in the public defense community to be sure that that's, you know, an idea that will work for them as well, because there's, you know, there's one.
Right. Santia, you have been so heavily involved with the second look law in Virginia. I want to ask you, you know, what has been your advocacy strategy for trying to get this passed and navigating the politics, and what kind of advice do you have for advocates who are doing this work in other states?
Totally. So Virginia is a very, very special place. Definitely know that there has not been a ton of movement in the state, you know, in the past X amount of years, but we've seen a lot of really cool things happen in the past few years after we had the Democratic leadership pretty much fully in the House and the Senate and the governor. It was definitely some advances made, but we still have seen that there's a lot of things that are holding us back as a state in terms of the way that people think about things, which includes our legislators, a lot of our leadership, and definitely the public. So we've seen a lot of work, and we've done a lot of work in the space for the past few years. And the Sistas in Prison Reform, I like to quickly tell our story. The three of us did not know each other before entering the advocacy space. And we started to see that we're saying similar things in town halls, on Facebook and in Twitter spaces and in different places. And we're like, wait a minute, I've seen this person, you know, online, but at some point in time, like I actually met Paletra at a rally because I didn't have an umbrella and she had an extra umbrella. And we ended up just talking about a lot of different things and found a lot in common. And the same went for Juanita. We connected online, and so she connected separately with Paletra and myself, which was crazy. And then all of a sudden we all started talking about it, everything that was going on in the advocacy space. And we were all really heavily advocating for extended earned sentence credits in Virginia. And then there was a point in time where the legislation changed, and it ended up being for only nonviolent offenses. And people were really upset. I was really, really upset because that meant that that people were saying that they were not redeemable, no matter, you know, who they are as a person. It's your crime is going to tell you whether or not you're able to earn good behavior, regardless of, you know, who you've become. So we were really, really frustrated about that and just started working together on trying to figure out how we can make it so that that isn't the case anymore, because as we all know, I mean, I'm in good company here, defining people by their crimes is not the right way to do anything. So we definitely, all three of us have loved ones incarcerated, of course, and that similar spirit. And we knew we needed to do something a little different. And that there was really that white space in looking at people for who they are today and not what their crime is. So there's just a lot of different laws and even like bills and different things out there that go at specific crimes. And we're like, wait a minute, that's just not it. Like, we just need to do something different. But if people don't know, Virginia abolished parole in 1995, and they also took away what was the current earned good time mechanism and made it so that there was truth in sentencing for 85% of your time. And even a lot of the public don't even know that we don't have parole, and just how bad the system truly is, because, you see what you see on TV and they don't realize that Virginia does things differently. So we knew that there was a lot of education to be had. But one of the things I know that we know that Virginia is just really different, just based on the political climate and many other things. But it really started for us with this bill process. It really started with collaborating with a lot of different organizations. I know we spent a lot of time talking to James, of course, because he's super well versed in Second Look and just different things like that. And really just talking to advocates and even incarcerated people themselves to try to figure out how best to draft this bill, and just thinking about the Virginia political climate. So when we first started working on this in May, we were really heavily involved with thinking about the election, of course, because we wanted to make sure that we kept a Democratic majority everywhere. And then when the election happened, we were like, oh, all right. So we're going to have a Republican House, Republican governor, which, comes with its own challenges, but obviously nothing is impossible. So we definitely wanted to keep going and find ways to make sure that we could find something in a concept that was going to be something that bipartisan support could come out of. So we definitely wanted to think about all of those things when we were forming the legislation. And just to name a few of the organizations we work with: Justice for Virginia, No Left Turns, Humanization Project, ACLU of Virginia, and many others. Of course, there's just so many people that have been involved in this. But again, I just want to quickly talk a little bit about what the bill is right now and the way that we've looked at the bill. So again, this legislation and our organization directly targets people who have done the work to rehabilitate themselves. So again, we talk a lot about our loved ones who we always love to list their accolades and all the things that they've accomplished. They mentor other guys. They've tried to better themselves after being in prison for. My loved ones has been in prison for 13 years. And then there's Pauletra's husband, who's been in prison for 22 years. And Sincere Allah, who recently actually got pardoned by the governor, which I can talk about later. He was incarcerated for 24 years. And, these men have completely turned their lives around in the time that they've been incarcerated. And we know that there's a lot of people in the system right now who have decades to go and have already proven by large that they're ready to come home. And we're like, why, even though they've been convicted of violent crimes, why can't they get, looked at in some form or fashion? So we had to really think about what that might look like. But we really also wanted to bring hope to those who have done work and just a desire for those who might not have done the work yet, and just saying like, wait, there's going to be something I can do to get out of here in less than a decade, like maybe get a shot at doing something. So we wanted to make sure we were thinking about that. But to quickly get into the nuts of the bolt, so people would be eligible to petition the convicted sentencing court after 10 years if they were under 25, and then at the time of the offense, and then 15 years if they were over 25. So again, we wanted to kind of bring that age element in there because we know that the brain development argument is out there. So we wanted to have something for under 25 and also for over 25, which is something that I know we all talked about the prosecutor initiated one that might include all ages, but we wanted to have something that was in there for people who were convicted after 25. But there's also the element that is what I've been talking about. They've proven they are ready to come home. So what this means is that during the past 5 years of incarceration, that people have maintained a GCA level 1, which is like a DOC issued behavior level, free of any major disciplinary infractions, and have one or no minor infractions in the past 5 years, which could be something like being in an unauthorized area. So we really wanted to focus in on that 5-year period, because we know that nobody's going to be perfect or spend their time in the incarceration, the time they've incarcerated, being perfect. Like that's just not going to happen. My loved one has infractions. I know there's plenty of loved ones who have been figured out after 5-7 years or so, like, wait, I can do more with my life, and really try to give myself to others, go to meditation. There's things that happen in people's periods of incarceration. So if anybody knows anybody incarcerated, usually you find that there's a time period where you're like, I don't have anything. There's no chance for me to come home. I'm looking down the barrel of 20 years and like, I'm, like, this is terrible. So we wanted to really try to think about what it meant to take 5 years to show anyone around that you are ready to come home and you've earned your second look, for lack of better words. But the way that we've looked at it is in the consideration and hearing process, the court would be able to take into account all proof that the petitioner is ready to come back out into society, which includes but isn't limited to their age at the time of the offense, their age now, programs they've taken, if they've been mentoring people, they've taken classes, anything. The record from the past 5 years is obviously going to be considered, any physical or mental abuse at the time of conviction, whether or not they were compliant with their case plans, they were employed, just looking at all of the things that they've done, during the time of incarceration, and being able to say, okay, this person is in fact ready for their second look. So we wanted to make sure that all of that was written into the language of the bill. And then also we really wanted to note that the bill was very well thought out. Like, we sat in rooms for countless hours talking about all the things that we should think about. So really wanted to think about the people, again, spending their time getting adjusted in while incarcerated. So we talked to incarcerated people at different facilities who've been there for different lengths of time, and they all agreed that there are ways that they can turn their lives around. A lot of them did do that, especially again after you're sitting there for a year and you're like, oh my God, I'm just never going to get out. So we know that is super possible. We also thought about like issues that people might have with facility staff. So there's a lot of different things you can do through the DOC that you can apply to say, like, somebody in the staff is bothering me for no reason, or is picking on me or targeting me. There's also a way that people with mental health issues can have a waiver involved. So we thought about that, and that's written into the bill. People who may be affected by mandatory minimums, that's written in there to say, like, you don't have to consider the mandatory minimum. Thinking about the victim rights, there's an extensive victim law that's out there, and that's noted in the bill. The operating procedures for the DOC is noted in the bill. And so we really did sit down and think about how we can make sure that we can include as many people as possible to get that chance at hope. And one of the things that I've been tweeting about personally was like, the way that we've thought about this is like, it's not really about, well, it is about people who are incarcerated right now that have been doing what they needed to do for the past 5 years. But what's really impactful is the person who gets incarcerated next year, and they know that they can take the 10 years and do the best they can, and they might not have to look down the extra 10 or 15 years that their conviction was. So it's not perfect by any means, and it's a little different, a little creative. Definitely wanted to keep into account some of the momentum that we've gained and the things that we've learned since all the special sessions in Virginia. Earned sentence credits passing was one of the things that was like the most major thing that people have seen for decarceration, even though it only includes half the DOC population who has the nonviolent offenses. But it was something that we were able to get so much momentum, and people were speaking about how that people are redeemable, and that people can earn their way out of being incarcerated. So it was a bit of momentum that we had from that we were really inspired by. And again, trying to find a way to take the crime out of something and make it so that it's really about people and who they are today. So
yeah, I love that focus, and thank you for giving us an overview of kind of how you have built that from the ground up and how you were thinking about the issues. Arienne, I wanted to go to you because you were also involved in crafting the prosecutor-initiated Second Look Act in Illinois. And one of the things that law has judges consider is the disciplinary history. And this is something that Santia said as well, something that I think about a lot in my second look work in the federal system with compassionate release, because I do think that there can be an overemphasis on, especially from prosecutors, on a disciplinary history, which I think is, can be very unique to the prison walls. I think it has very little to do with what, someone will do outside of prison because of the terrible conditions that exist in prisons.
Mm-hmm.
So I'm just wondering how you're thinking about that factor, how prosecutors will be arguing that, and how, you're thinking about expanding this law as it goes forward.
To work my way backwards, I don't know that we've had conversations about expansion at this point. So we are so new into the law as it currently stands that we haven't thought about what the future looks like with this law in terms of any possible future legislative tweaks to it. And I don't know that we will for some time. We want to use it as it is and just really give it a run and see how much impact we can make with the law in its current iteration. But in terms of disciplinary histories, thank you for mentioning that, because when I also work on clemency matters in our office, we look at disciplinary histories for what we're calling like the major violations. And anyone who's read an IDOC disciplinary history knows that a major violation can be insolence, but that is not what we're looking at. We're looking at real major violations. So fighting, sexual misconduct, and what the nuances are behind that, because we also know that, giving someone a Valentine's Day card may be considered sexual misconduct. Gang activity, especially if your crime of conviction is the result of being a noted member of a gang. And we don't look back for long sentences. We're not looking back to, the 1980s. If you've been in for that long, certainly we will see your disciplinary history from that time. But essentially, we're looking at what have you done in the last 5 or so years. Because for folks who are serving long sentences, especially those who go in when they are younger, we know that when you get in and you're young, you're a little hot-headed, like Santia so beautifully said, you're looking down the barrel of a long sentence, and so there isn't much hope for what the future is for you and what it could be. And we understand that, but certainly both age and maturity, and also just the harshness of the penal system calm people down a lot of times. So there are going to be folks who still have, disobeying an order for not tucking in their shirts. We don't care about those things. We're looking at the real serious crimes. And certainly when we make these motions, a court will have full access to the entirety of an incarcerated person's disciplinary history, but we're not going to emphasize these small things. Indeed, we've seen an uptick in people receiving tickets over the last 2 years during the pandemic for, disobeying orders, for not having their mask up, for insolence. But we also understand that the last 2 years have been very unique, certainly for all of us who are not incarcerated, but especially for those who are in a world where there are already so many restrictions. That added stress of COVID restrictions within penal institutions has created frustration. And of course, people are going to realize that with, a taught word or something like that. And so we are certainly trying to ensure that going forward, we're always looking at disciplinary records holistically, and that we're doing so in a way that really does allow us to embrace the nuance and the complexities of what life within a penal institution is like.
That's good to hear. Thank you, Arienne. I want to turn a little bit to litigating once you have the second look law in place for attorneys who are taking these cases. Mary and James, what are some of the best practices for litigating second look motions? What information do you think judges find most persuasive, and how can attorneys best tell people's story in these motions?
James, I'm going to let you start because you're actually litigating motions, and then I'll back clean up.
Sure. And I want to take this opportunity, if anyone saw the range of facial expressions while Santia was talking, we actually just learned that the judge granted a compassionate release motion for one of our clients who was terminally ill. And so he'll get to spend this last year of his life at home with his family and not in a U.S. penitentiary. So, and that was Maggie Burkell, our supervising attorney, and our extern Megan really did all the work on that one. So that was a bit of good news. But so talking about how to litigate these cases, the biggest question I think that we find that judges have and that we're confronting really is about the dangerousness piece. And that's one of the threshold determinations that the court has to make. And as someone also said on the last panel, like the biggest concern that these judges have is that they're going to release somebody who goes out and commits another violent offense. Like that above and beyond all else for most judges is the animating concern. And, so it really means kind of finding ways to kind of flesh out who the person presently is as much as possible to kind of demonstrate why, to convince a judge that if this person comes home, that they're going to be not someone you have to worry about, that they are kind of a pro-social person, that they, are prepared for kind of the challenges that life is going to present. And sometimes that's easy, sometimes you have someone who doesn't have any of these meaningful disciplinary infractions, who doesn't have an infraction of any significance in the last 20 years and has gotten their college degree while they're incarcerated and has done all these things. And that's an easy sell. But, as we were just talking about, it's not always that straightforward to a judge's eyes, especially because, most of our clients are in medium and high security federal facilities. They're violent facilities. It is frequently difficult for people to avoid that environment. A lot of people possess knives at one time or another as a kind of necessary survival and defense mechanism, and some judges are more willing to kind of accept that reality than others. And so, we have to kind of do everything we can to convince a judge why things like that, because it's not the slam dunk cases where this is hard. It's the ones where it's the history is a little more complex. And so sometimes we use forensic psychologists to do evaluations of clients and provide a clinical opinion that this is someone who's unlikely to commit future violence. We try to be judicious in our use of those experts because we also don't want to create an environment in which judges are expecting that in every case. We use prison experts who can tell a judge, which is someone who's usually a former administrator or warden in the prison system where the client has been confined, who can testify to a judge or write a report that says, this person was at USP Big Sandy in 2010 and they got caught with a knife. But let me tell you about U.S. penitentiaries generally. Let me tell you about what Big Sandy was like in 2010. And let me explain to you why it is a reasonable and kind of commonplace practice for people to possess weapons for self-defense in that environment, and why that doesn't necessarily transfer. And so, and the prison experts can also kind of draw out positive trajectories and show, why a programming accomplishment that a client has is really so significant or so probative of the kind of pro-social values that we want to draw out. And reentry plans, are another kind of vital way to show that, if this person comes home, that they're going to have a kind of supportive structure in place waiting for them. And I think this is a function of the way our statute is drafted, that it really does, our statute has so many factors that are beneficial to petitioners, and that the basic premise of the law that people change is kind of baked into it. And I think the proper kind of reading of our law and the way it's most usually been applied is that if someone is not dangerous anymore, that they should be released. And that the 15-year required time period is presumptively adequate for the purposes of punishment. And that beyond that, we're really just talking about, is this person safe or not? And that doesn't mean that's the only thing that we have to kind of convince judges of. And sometimes, every case is different. You kind of pick the narratives that are most useful. But, it's addressing, making a judge feel confident that if they let somebody go, that they're not going to see their name in the paper. That's far and away the biggest thing.
Yeah, I don't have a lot to add to that. I will say that creating a picture of the whole person is super important, like telling the story about the whole person. I mean, some of these second look mechanisms in parole go back to the original crime of conviction and freeze the individual at that. And so in our advocacy to create new laws, we want to get away, obviously, from that frozen picture, but also, certainly it's sort of interesting because we're trying to use the compassionate release bill at the federal level as a second look law, right? And the one limitation that we have is in the law is that rehabilitation alone cannot be an extraordinary and compelling circumstance, which is the standard for compassionate release in the federal system. It's like upside down backwards, but it does force us to get creative, both in talking about the individual and then also as we use it as a second look to identify ways in which this individual would not have been incarcerated for such a long time had they been sentenced today. And one of the terrible features of our law at the federal level is that we've gotten into a little bit into the habit of passing a sentencing reform here and there, but not making it retroactive. So we don't go back and identify people who ought to be considered for early release. So, I mean, some of the best lawyering that's going on right now is going back and finding those people and telling those stories. And then I'll just add to the reentry plan issue. That's so important, particularly, I think, in state systems less than in our federal system, but there are people who've been in for a very long time. They may have been convicted of pretty serious offenses. They may have lost contact with family and loved ones. And so I'd encourage in those situations, we worked with social workers in the clearinghouse, social workers volunteered for us in the clearinghouse to sort of help us craft release plans for folks or do the millions of phone calls to find the one nursing home who was going to take the person who'd been convicted of a sex offense in the state of Iowa or Texas or wherever it was. So I think that sort of making those connections. There was a terrific set of cases out of Maryland, the Ungers, a number, mostly gentlemen who were quite advanced in years, who were eligible for resentencing and were resentenced, but they had been in prison for decades. And the University of Maryland's law school teamed up with the University of Maryland Social Work School to sort of do a soup to nuts support system for them. So, just getting creative about who you're going to call on to help as well.
And if I could just add one thing on to Mary's point, one thing that we have found really kind of important and valuable in these cases is, and this kind of is a tax on to the having a prison expert who can tell, a judge about the prison, but is if you can find prison staff or facilitators who have known your client while incarcerated who will say good things about him. And maybe you can get them to write a memo to the file or a letter, and that's great. Most facilities have policies that discourage staff from doing that. And so sometimes you've got to subpoena them. But, judges are really scrutinize the credibility of witnesses who come and speak on your client's behalf. And if you can get a correctional officer, correctional program facilitator to come in and tell a judge how great your client is, those are, I think, in our experience, some of the best witnesses.
Agreed. We had a retired caseworker just happened to retire and had worked a bunch with one of our clients, not in a compassionate release case, but in a district court case. And the judge found it to be the most compelling letter of, 30 letters that we had submitted. So I totally agree that can have huge power. This panel has absolutely flown and we have about 10 minutes left. So I'd like to end by having everyone touch on some of the challenges that you've faced doing work in this space, and then to end on the hopeful note, what makes you hopeful about the work that you've done, and why we should all feel hopeful about this area. So I would love to start with Arienne, Santia, and go to James and Mary.
So in terms of challenges, certainly I believe that one of the challenges was whether or not this was going to pass through the legislature, quite honestly. We were very lucky in that we have a supermajority of Democrats in the House and in the Senate, actually. But one of our concerns was that, even more conservative Democrats would not appreciate this for what it was. And certainly there was concern that there'd be backlash from other law enforcement agencies if they didn't understand or didn't want to recognize that this law is meant to be fully discretionary and is not meant to usurp the rights of victims or to downplay the traumas that they've experienced because of having been victims of crime. So that was certainly one of our considerations and one of our worries. Now that we are getting to the point where we're really ramping up here in Cook County and preparing to use this robustly, we're certainly also having an issue with just all the requests that are flowing in. And so we're trying to make our policies and processes as clear as possible and really acknowledge, one, that there are still limitations to this, and give people the information they need to use the proper option. So just kind of a capacity issue on that end. And I think 3, a concern for us that we don't really have any power over is that some of the smaller and more conservative counties aren't going to use this. People in Cook County who are in the penal system right now are not the only ones who deserve to come home. And certainly we want and would hope that other counties would recognize that. But we also know that we are limited to what we can do for our incarcerated population. And though Cook County does have the largest population of IDOC incarcerated persons, we just are really cognizant of the fact that other people certainly are deserving of relief and release. In terms of what makes me hopeful, we are very close to filing our first motions for our first candidates. And I'm just so honored that we have a state's attorney and folks in our office who are so dedicated to this work and who really do understand that taking a second look at older cases is not necessarily an indictment of the individual prosecutor who prosecuted the case or the individual office, but it really is just a recognition that times change, people change, and we need to ensure that we're not just leaving folks behind simply because they were convicted of a crime prior to our evolution in thinking and knowing. So I'm really hopeful just about where we can go with this, what we can do with this, and the possibilities that the folks who may one day be resentenced either under this law or just in compassionate release or clemency. I'm just really hopeful about the future for those folks, and really hoping that if and when they are released, they are able to live again these robust and full lives outside of, 1, the confines of the penal system, but 2, outside of the confines of the crime that landed them there.
I really think that, and we've talked about this the whole time, but the political climate has definitely been a really big challenge for us in Virginia. Again, I've already talked about the House of Delegates and how tough that might be, but there's a lot of people on the same party line, on the other party line, that aren't thrilled either. Like they're not like particularly like, yes, criminal justice, prison reform, let the people out. I'm like, yes, let the people out. But we know that's gonna be difficult because a lot of people don't have that lived experience to kind of understand what it means to kind of be knee deep in this industry. Like all of us, this is kind of our daily life, and we get exposed to so much. But a lot of these people are just literally blind to the way the system works now, especially in Virginia. But we've done a whole lot of work to gain the bipartisan support. And I do think that finding that common ground and redemption has been a way that we've been able to win over some hearts and minds, not all hearts and minds, but some. And we've just found a lot of power in human stories. I think we're really hopeful about getting more done in the state. Like in Virginia, again, there's virtually no chance of post-conviction relief for the most part. But we've made some really good strides in the past few years. Like I mentioned earlier, like there's the earned sentence credits enhancement for some, juvenile parole, and then there's a lot of other different pieces of legislation that might help get people out. But we really wanted to create something that gave people hope and, something to look forward to. And again, it's not perfect, but just knowing that there are these little pockets of things that we found to help get people out. Like this is just the next iteration of that, like creating something that we can easily say, this encourages public safety on both sides of the wall. And then you get like different ears that might not have listened before being like, like my senator is one I thought I was going to have to fight because she typically doesn't really deal in the space, but she was able to vote yes on this because she knew that this bill was something that she could support and she could put her guts behind, so she voted for it and it was awesome to see. But I think really just going through the House of Delegates, which is our next stop in Virginia, is just keeping that human spirit alive. Like one of the coolest things that we've gotten to witness is seeing Sincere go to the House of Delegates and virtually like shut down people who will say incarcerated people, blah, 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 incarcerated people. Like they can't even say anything because they're standing there right in front of them testifying. And you're like, well, this is me. And this is, I'm here. And I'm proof that people are redeemable and people can spend time in prison and come out fighting in the General Assembly in front of you in person. And it's just super powerful. And I hope that we can continue, doing work like that and getting this bill passed.
Absolutely. We are rooting for you guys and done amazing stuff. We just have a few more minutes. So Mary and James, perhaps you could give us your hopeful thought.
I'll just echo Santia. That Virginia bill is a thing of beauty, and it's an inspiration. It's also another bill that's up against some headwinds because of the attacks that are being made on some of these efforts right now. Great bill in New Mexico just got pulled because of those kind of attacks. What lifts our work up is my organization is an organization of currently and formerly incarcerated people and their loved ones and others. And I am when we're an advocacy organization, we don't do all the litigation, but we are constantly amazed at the generosity and the patience and the courage and the willingness and the givingness of people to sort of be there with us and have our backs. And that's what gives me, I wake up every day and go, yeah, let's get this done. And if we don't get it done, they are right there with us next session. So
just real quick, the challenges, when we first started doing this, it was kind of halcyon days. We didn't have a lot of big obstacles. We had a small client population and we had a lot of kind of institutional stuff in our favor. And then with COVID and with this big increase in our client population, we've faced some real challenges in terms of accessing our clients, getting our cases heard, getting the resources we need. And it's become a much bigger lift. But the cause for optimism, I think, is that, so many people in DC have this opportunity now to come home and show people in a very kind of real and tangible way that second chances matter and that people change, and that so many of these people, including the people who are convicted of very serious offenses, can be released, not just safely, but in a way that makes the community better. And I hope that not only will DC benefit from continuing to see that, we've seen it over the last several years, but that we can kind of show other places too, kind of an example that this works and it can work for them.
Well, with that, thank you all so much. You all are incredibly inspirational, just hearing about what you're doing and the thoughtfulness with which you are all doing it, I think has been, wonderful for everyone to hear. And having a mid-panel compassionate release grant, I think was more than we could have hoped for on a panel like this, and really just shows what we're all fighting for. So that was wonderful. Thank you all for giving your time to this symposium.